This is LXBN TV, and I'm Colin O'Keefe. In a case that has implications for the reach of the Supreme Court's ruling in Comcast Corp v. Behrend, a federal court in New York recently denied certification to a class of unpaid interns working with Hearst magazines. Joining me to explain the case and its impact is Bill Allen, attorney with Littler and author on their blog, Wage and Hour Counsel. Bill, first, can you explain why this class wasn't certified? What are the primary reasons here?
Yes, Colin, there were three reasons. First, the court found that the commonality standard hadn't been satisfied under Rule 23. And under the Supreme Court's ruling in Dukes v. Walmart, it's not enough just to show common questions anymore, but there has to be, even if they're in droves, there has to be common answers that drive the resolution of the litigation. And so in this case, the court found that there were so many varieties of internships at Hearst Corporation, which covered, by my count, at least 10 or 12 magazines and even more. And so there was no way for the court to determine what the intern's actual duties were using common proof. The second reason was the predominance standard. And it noted, and Comcast has noted this recently, the predominance standard is a higher hurdle than commonality. And so it found that in order to make liability determinations, it would have to do an individualized inquiry on 4 of the 6 factors that the DOL uses to determine if unpaid internships should actually be paid employees. And then the third reason was that it didn't satisfy the superiority requirement as well. Because of all of these individualized inquiries, the court found that case management would be difficult, if not impossible.
I see. So second, you wrote on the impact of the recent Comcast decision in this case. What role did that play here? And does this hint towards a broad application of that decision?
Comcast actually was not determinative in this case. It was more of an aside that the court made, that it hadn't, in deciding predominance, it hadn't reached the question of whether there were individualized damages issues. What was interesting is that the court specifically rejected the plaintiff's argument that Comcast was limited to antitrust cases. And so it's another view of how courts are interpreting Comcast. And to my knowledge, I'm aware of 4 cases since Comcast came down where courts have applied the holding to wage and hour class action. And so that's a very exciting development for employers if that trend continues. Now, there's certainly been a couple other cases that found ways to distinguish Comcast, one of them being it was limited to the antitrust area.
I see. So lastly, what is the significance of Comcast Corp v. Behrend for employment lawyers? What should they be looking at? Are there certain strategies they should employ? What is the significance here?
Comcast has the potential to be a very important weapon for employers to defeat class certification. Traditionally, district courts and courts of appeals had found that individualized issues involving damages alone was not reason to defeat class certification. Comcast may change that. And so it's important for defense counsel to be looking for ways to create individualized issues involving damages when they're doing discovery, when they're taking depositions, and when they're formulating their oppositions to class certification. There seems to be, for instance, off-the-clock cases and meal period cases have been fertile ground for making this Comcast argument. And we're already seeing that lawyers everywhere are starting to figure out how to use it. Of course, it's important that the court is open to the idea of applying Comcast in that way.
Very interesting. It's going to be interesting to see how this plays out, to see how Comcast is applied not only in employment law, but also in other areas of law as well. Once again, that was Bill Allen of Littler. For more of his insight on this case and on the impact of Comcast, be sure to visit wageandhourcounsel.com. And as always, visit us at lxbn.com, where we have really hundreds more of these LXBN TV interviews on a number of different subjects. And of course, we also have curated commentary from the Lux Blog Network's more than 8,000 members. Thanks for joining me today, Bill.
Thank you.